Pinangunahan ni Senator Mark Villar, Committee on Public Works Chairman, ang pagtalakay sa Senado ng Republic Act 10752 o Rights of Way Act kung saan ito ay naglalayon o tumutukoy na pag-grant sa mga individual o sa national o local government na pagbibigay ng karapatan na makapass through another's land o makadaan sa isang lupa na pag-aari ng iba, lalong-lalo na kung ito ay essential para sa access ng isang property o ng isang lugar. Ito yung kadalasang nagiging problema ng mga tao na kung saan kapag hiningi o kinailangan ng gobyerno ang parcel ng lupa mo ay wala kang choice kundi ibigay ito. Ibigyan ka naman ng danyos o kabayaran pero sabi nga nila hindi sasapat ang binabayad dito. Pero no choice ka kasi nga kailangan o essential ito para sa ikauunlad o mas ikabubuti ng pamayanan. At dito nga sa Senado, tinalakay ni Senator Mark Villar, Committee on Public Works, ang RA 10752 o karapatan ng mga individual o ng gobyerno na angkinin o kunin ang mga property na maaaring makadagdag tulong sa saayos ng isang pamayanan at kung ano po ang mga scope at limitations at karapatan ng mga tao ukol dito. Sa kasalukuyan ng mga naepektuhang mga lugar ay dahil sa pagpapagawa ng PNR o Philippine National Road, ito yung mga MRT, LRT, o yung mga right of ways para sa mga vehicles. Gayon din yung pagpapagawa ng airport dito sa Bulacan, meron din ganyan. At talagang maraming mga kabahayan o pag-aari ang sasagasaan. At dahil dito, tinatalakay sa Senado in aid of legislation kung ano ba ang mas dapat gawin na magiging patas sa isa't isa.
For today's hearing, the committee will discuss the legislative measures on the amendment to Republic Act number 10752 or the Right-of-Way Act, House Bill number 6751, an act providing additional guidelines in the acquisition of right-of-way site or location for national government infrastructure projects, amending for purpose Republic Act number 10752, otherwise known as the Right-of-Way Act, Senate Bill number 1537, an act amending Section 5 of Republic Act number 10752, otherwise known as an act facilitating the acquisition of right-of-way site or location for national government infrastructure projects and for other purposes. Senate Bill number 2718, an act instituting reforms in the acquisition of right-of-way for infrastructure projects by the national government and by public service providers, amending for the purpose Republic Act number 10752, otherwise known as the Right-of-Way Act. Senate Bill number 2765, an act providing additional guidelines in the acquisition of right-of-way site or location for national government infrastructure projects, amending for the purpose Republic Act number 10752, otherwise known as the Right-of-Way Act. At this point, please allow me to make specific House rules to ensure the orderly and efficient conduct of the hearing. Can the committee secretary inform today's attendees of our House rules?
Kindly mute your microphone if you are not recognized. Since the chair cannot see everyone at once, feel free to get his attention by specifying your name and that you have something to say.
Kindly ask for permission first from the chair to be recognized before speaking. Improper behavior will not be tolerated by this committee. Before we proceed with the hearing proper, may I ask, make a question later. I will ask a question later when my colleagues are here. So at this point, we proceed with the public hearing for the amendment to Republic Act 10752 or the Right-of-Way Act. Delays in infrastructure projects are often rooted in the delays of right-of-way acquisition. Nung ako po ay secretary, ang favorite saying ko po ay if you deliver the right of way, we can deliver the project right away. So when I was secretary of DPWH, I encountered multiple delays in many high-impact infrastructure projects under the Build program. It was a recurring problem through my tenure as secretary. It was something that we had to meticulously deal with through several department orders based on the Right-of-Way Act every time we were pursuing a project. As a result of these expanded procedures, we are now able to enjoy several high-impact infrastructure projects such as the Metro Manila Skyway Stage 3, NLEX Harbor Link Segment 10, and the NLEX SX Connector. And I'd like to welcome my colleague, Senator Robin Padilla, to the committee hearing. Thank you for your time in joining us. And with the presence of Senator Padilla, I declare the presence of a quorum. Sige. Mahirap po ang proseso ng acquisition of right-of-way na talagang nakakaapekto sa timeline ng ating mga projects. For example, it took 6 presidents to complete Radio Route 10, a 9.7-kilometer expressway from Delpan Bridge, Tondo, Manila to the mouth of Malabon River at Bangkulasi Bridge in Navotas City. We need to make significant tweaks to the current law in order to make it responsive to the needs of the implementing agencies. It is crucial to know how the Right-of-Way Act could be amended so it would be in sync with the dynamic changes in our infrastructure landscape. We also need to ensure that the implementing agencies will be empowered to fulfill their mandates once the law has been amended to fit the contemporary needs. Additionally, I am also looking forward to how we can harmonize and align the Right-of-Way Act with recently legislated related measures such as the RP-VARA and the PPP Act. Apart from this, kailangan din natin masigurado na itong amendment sa Right-of-Way Act will solve the compensation issue of private property owners affected by government infrastructure projects. We must ensure that moving forward, they will be provided with timely and just compensation. The just compensation is a time-honored principle enshrined in our Constitution. At kailangan natin masiguro na makukuha ng ating mga affected kababayans ang worth ng kanilang properties. We must develop our infrastructure landscape, but of course not at the expense of our fellow Filipinos. As the former infrastructure czar, naniniwala po ako na solving this bottlenecks right-of-way acquisition will give us high-impact infrastructure projects that are delivered timely and efficiently. Gamit ang solusyon na ito, mabibigyan po natin ang ating mga kababayan ng mga proyekto na makakatulong sa kanilang araw-araw na buhay at sa ekonomiya ng ating bansa. To start, at this point, we can start with the presentation. So, meron po bang mga presentations? Yes, please proceed, sir.
Good afternoon, Mr. Chair. The Department of Transportation has a presentation regarding proposed amendments to the Right-of-Way Act. Mr. Chair, if it'd be allowed for me to speak to the Secretariat for them to flash the presentation of the Department of Transportation. Good afternoon, Mr. Chair, senators, and other members or attendees of the committee. Essentially, while the DOTR has several amendments that we proposed in our position paper for today, just for the highlight of the committee, we would like to highlight particularly our request for amendments to the subterranean right-of-way for subway projects. I believe everyone is aware that the Department of Transportation is building the Metro Manila subway project. We'd like to emphasize and repeat that this will not be the last subway project, and our proposed amendments to the Right-of-Way Act. With that, we hope to build even more subways, not just in Metro Manila, but also in our other urban centers throughout the country. Next slide, please. Next slide, please. Thank you. Just to summarize, our proposed amendment to 10752 is to reduce the depth of the subterranean right-of-way from 50 meters, 50, to 15 meters from the surface. This will essentially allow the Department of Transportation and other government agencies to build more subterranean infrastructure. Next slide will show our two main reasons. One is to future-proof our infrastructure planning and infrastructure development, particularly with mass transportation systems, as well as improve and enhance safety for those passengers who will be using those subway systems. So we will give some examples. Next slide, please. I think we're all familiar, for example, or some of us might be familiar with the subway system in Tokyo. This is a very 2D map, but actually the real situation here is next slide. We can see the 3D map of those subways. Originally, Tokyo had few railway lines, subterranean railway lines, but over time, as their network grew, they had to dig deeper and deeper underground. It's hard to see it here, but I think the next slide will showcase the depth over time. So on the x-axis, we have the years. So the first subway of Tokyo was built in 1935, the Ginza Line. That was around, this is from the Japan Ministry of Land, Infrastructure, Transport, and Tourism. The Ginza Line was 16 meters underground. This was built in 1934. As we know, World War II happened, so they didn't build a subway line. The next subway line that they built, 17 meters underground, the Marunouchi Railway Line. And over time, as their subterranean space was used for subways, they had to build subsequent subways underground, even further underground. Their most recent subway line is the Oedo Line. You see that on the bottom right. That was in 2000. And the depth of that was 49 meters. We would like to note that that's actually less shallower than what we currently have in 10752, which is 50 meters. And since we are not here yet where we have several subway lines, but this is where we want to get to, we need to start shallower. And this is why the Department of Transportation would really want the amendment considered for a shallower a depth for our subterranean right-of-way from 50. Again, 50 meters even from Japan is very deep. But we would like this raised to around 15 meters. Next slide. So this is regarding the future proofing of our subway systems. But I guess one of the other major aspects that the Department of Transportation wants to ensure when it comes to our current and future subway lines is the safety of passengers. The depth of our subways or our subterranean infrastructure doesn't matter if it's for a sewage line, electricity, gas, they don't care. But when we have to evacuate live passengers, persons with disabilities, senior citizens, it matters to evacuate them from underground. Right now, a 50-meter evacuation, for example, wouldn't matter if it's above ground. A 50-meter building would be around 18 stories. Going downstairs isn't as challenging as evacuating going up. So we want the depth to be shallow to make sure that we're able to evacuate our passengers safely. So we do have some standards that we look at, especially when we're building our current subway line. Again, a good reference is the Japanese standards. So they have standards, for example, for the safety of evacuation of passengers. The next slide will be a bit technical, but essentially how we measure evacuation for subterranean infrastructure is in a matter of minutes. So in this case, for example, we do want to be able to evacuate people around 6 to 10 minutes when there is an incident. That's the safe margin usually. Next slide again showcases the future of our subway systems here in the Philippines. We are intending to build subways in Cebu, in Metro Cebu. We have the Metro Manila subway. That's actually only phase 1, what we're building right now. We're already preparing for phase 2. We have MRT4, MRT5 here in NCR. We're looking at the Alabang Zapote secondary line. I like to add here the Mindanao Railway projects, both phase 1 in the Davao area and phase 3 in the Cagayan de Oro area. We're currently discussing with LGUs in Cagayan de Oro Metro. And here we are seeing that we do have to tunnel also in the downtown area because as we know, the above ground urban area is already built up. So as we develop our cities, as we grow economically, it becomes very surface right-of-way becomes very valuable, and maybe the only option for us is truly to go underground for subways.
Just a reminder, sorry to interrupt. Just a reminder, maybe some details we can discuss in the technical working group. We can build, siguro medyo mas broad na lang yung presentation natin. But kasi after this we will break up yung technical working group. Or we can go deeper into the details. Thank you.
Thank you, Mr. Chair. I guess I just have 3 last slides, which I'll run through really quickly. The next slide are examples from other countries. Next slide, I think in Singapore, they recently amended their right-of-way law so that 30 meters and below would go for government subways. This is also because Singapore has built several subways already and they have to keep going deeper when they want to build more subways. Next slide, we have some examples from Europe. Helsinki, actually, it's around 6 meters. And then the last slide in Montreal, I think it's actually, next slide, 10 meters underground. So it varies, Mr. Chair. And that concludes our presentation from the Department of Transportation.
Thank you.
Thank you.
Are there other presentations or just one? There's a DPW. May presentation pong DPWH, correct? Is there?
Mr. Chair, we have with us this afternoon our written position paper for the proposed amendments to the Right of Way Act. In summary, Mr.
You
Chair,
can summarize.
we
Yes.
can mention that the comments contained in our position paper is themed around the current conditions on the field and the reality that right-of-way funding is really very limited for DPWH. So in our list of recommendations here, Mr. Chair, everything is geared towards maximizing the allocation for right-of-way acquisition and streamlining the process of right-of-way acquisition. Because as it stands right now, Mr. Chair, the entire right-of-way acquisition process will take at around 2 years. 1 year for ideally for the preparation of the right-of-way acquisition plan, and then the right-of-way acquisition process itself, Mr. Chair, can take about a year or 6 months to a year, under ideal conditions. So one of the challenges that DPWH is facing is the validity of the fund for the right-of-way acquisition. Under the cash-based budgeting, the validity of the fund is 1 year to 2 years. And under the DBM guidelines, the right-of-way funding is not among those classified for comprehensive release, meaning it is not released immediately upon the effectivity of the GAA. It is for later release. So we are dependent on the issuance of the SARO, which this year, Mr. Chair, came at the later part of the first quarter. So it is really a challenge to comply with the requisites in order to disburse the funds.
So USEC, so you're saying USEC that the provision where the DPWH or the relevant government agency is required to finish a right-of-way plan prior to implementation may not be realistic. And I can vouch for that also from personal experience, that sometimes in budgeting there are items that were not part of the original NEP, that were amendments, so they were not the necessary preparations were not made, because you cannot anticipate what will come out in the GAA, and you can only recommend. So I understand that point, and I think we should all, the committee should take notice of that. In an ideal world, yes, we should have a plan, but at the same time, we should be a little flexible, because you have to award it within a year, and you have to implement it within 2 years, diba? So your point is well taken, and we should note that in the committee. I think the point of USEC, Lapus, is very well taken. So that's correct. I assume that's what I was gathering from your statement, that this. What would you propose as an alternative?
Mr. Chair, first of all, I would like to extend our appreciation to this committee for considering our initial recommendations to the proposed amendments of RA 10752. Maybe a few points, Mr. Chair, for emphasis, in line with our advocacy to maximize the budget for right-of-way funding, is maybe in coming up with a standard value for the price or offer for the purchase price of the right-of-way acquisition.
Have you studied how the RP? Sorry, excuse. Have you studied related to that the RP Vara? Have you studied that and its implications toward this law?
Yes, Mr. Chair. in summary, the RP Vara is a good law. It will provide a standard value that may be used by all government agencies, for DPWH for right-of-way acquisition in the appraisal, and other government agencies for taxation purposes. With respect to right-of-way acquisition, Mr. Chair, we will be able to use the standard value provided under RP Vara for right-of-way acquisition. It will limit, or it will lower our cost for acquisition, because we will no longer be required to purchase or procure in the independent property appraisals. And we will no longer be required to engage the services which requires costs for GFIs. So if we have one standard value, Mr. Chair, it will be easier, because it will lessen the time, because we will no longer need to procure IPAs and GFIs. So it is a good law. However, it is still in the process of issuing and implementing rules and regulations, which I understand, Mr. Chair, will take about 2 years so that the law will be effective. In the meantime, DPWH is coming up with interim measures to address the gap with the issuance of the RP Vara. But DPWH is really very appreciative of the RP Vara, Mr. Chair. So we also propose that we adopt it in the amendments of the Right-of-Way Act.
Yes, thank you. And I also, before we move, I'd like to acknowledge the presence of our Majority Floor Leader, Senator Tolentino. Thank you. Mrs.
Just a quick retort.
Yes, we recognize, the chair recognizes Senator Tolentino.
Chairman, I just overheard something. It will take you 2 years to craft an IRR. That's more than half the life of a congressional term. Ganun katagal ba ho gawin yun?
Mr. Chair, I stand corrected. Not only the IRR, the scheduled market values under the RP Vara law will require consultations and public hearings. It is outlined under the law po that the whole process will take about 2 years po, excluding the time for crafting the IRR, which will take about 6 months.
Is
6 months.
period, and you can go faster. So you intend to complete that not within, but at par with the deadline.
Mr. Chair, the coming up with the schedule of market values is an interagency collaboration between LGUs, the Department of Finance, and the BIR, as I understand. Timelines have been set under the law, Mr. Chair.
Can we request the DOF? Maybe you can comment on this possible timeline for the reconciliation between the RP Vara and this law.
Yes, Your Honor. We're presently crafting with the BR the rules regarding the RP VAR.
What is your timeline?
Your Honor, we intend to submit to the Secretary the draft IRR by October.
Over, not 2 years.
The IRR, Mr. Chair, will be ready in October, but the updating of the schedule of values itself, Mr. Chair, will take about 2 years as provided under the law.
Other questions? Just came here to provide you additional quorum support, Mr. Chairman.
Thank you.
And thank you for being a very active Deputy Majority Leader.
Thank you.
And belated happy birthday as well.
Thank you.
Birthday niya kahapon eh. Kaya wag niyong pahirapan yung chairman ko.
Thank you. Thank you very much, Senator Tol. And I also have a question regarding the With the RP Vara, once the or no, let me go back to the subterranean for a moment. I'm curious about, and this is a technical question. Di ko lang alam kung alam mo yung sagot sa tanong ko. But anyway, I'll ask it. In terms of ano pong effect sa, halimbawa, ako yung may-ari ng lupa at 15 meters na yung, what does that preclude me from putting up a building? Ano bang magiging effect sa property owner?
Mr. Chair, with regards to the ability to build on top from if there's a tunnel. So the tunnel has, if we build a tunnel, say the tunnel boring machine, there is a load that that tunnel can support. There are examples where we've tunneled and then we can build a building on top of that. So I guess the limit will be the load that the building will have. So if it's a single-story building, it should not affect it. But if it's a high-rise, I think the tallest building in the Philippines right now is the one in the Grand Hyatt, that's 300 meters. It would be difficult to build that with a subway tunnel. Now with the subway naman, sir, with the tunneling, we will not touch any existing structure. And as much as possible, we will still try to utilize public right-of-way. However, there are instances where we do have to tunnel underneath private properties.
Yes.
And in those instances, we try to minimize the impact to potential high-value structures. Especially, so it depends on the zonal zoning. If it's commercial compared to low-density residential, for low-density residential, it should not affect the ability to build pretty high. But for the exact technical standards, sir, yes, we would have to get back to you on the TWG for that one because it differs from place to
Kasi I
place.
can foresee, siguro baka magkaroon tayo ng maraming scenarios like idadaan natin, baka may existing building na. And even though it's 40 meters, baka may effect din sa structural integrity ng building. So ano maging compensation ng building owner kung hindi siya papayag, or pwede ba natin pilitin yung owner na maglagay ng subway sa ilalim niya? So, I mean, maybe you comment some scenarios.
Yes, sir. If it's an existing building,
Yes.
we are able to tunnel. And so long as we don't impact the foundations, that means we have to go deeper than the foundations. But it's going to be very difficult to look at future construction. What we're doing right now for the subway project, if there is existing foundations, we avoid it. So for example, we are tunneling under gas stations. So we're lower, for example, than the storage of the fuel. So there is a the technical terms are it's 2.5 times the radius of the tunnel is usually your easement from the nearest foundation. So I guess we'll bring in also perhaps some of our Japanese engineers here.
And I
But
think,
there is ways for us to tunnel underneath.
yes,
existing
and I think
structures.
for future, we should also have representatives from the real estate sector so they can also comment, some specialists, maybe some engineering specialists, so that we can also anticipate any possible scenarios in the future. Should we lower the threshold for subterranean right of way? I think it's a very technical question to answer. So I'd like to direct the committee in the future. We can invite some technical people and maybe some representatives from people who build, I don't know, siguro mga developers also, yung high-rise developers who might be affected. But I remember when I was secretary, usually hangga't maaari talagang dinadaan nila sa ilalim ng kalsada, public road. Hangga't maaari. I remember with the subway, it was under C5. So I know, but like you said, there will be some cases probably that will require boring underneath a structure or on a private property of an individual. So I think we have to just anticipate different scenarios in the law, and we can take that up in the technical working group. Yes,
One question, I'd
Senator
address this
Tondino.
to the Department of Justice. You answer this. How can you reconcile this, the statement just given by ASEC Veles, with Section 437 of the Civil Code of the Philippines, which states that the owner of a parcel of land is the owner of its surface and everything under it, and he can construct thereon any works or make any plantations and excavations which he may deem proper, etc., etc.
Yes, Your Honor. Good morning. Good afternoon, Mr. Chair, Your Honor. Yes, Your Honor. The owner of a property, his ownership would extend to the subterranean as well as the aerospace, Mr. Chair. So, if the subterranean is affected, then he is also entitled to just compensation, Mr. Chair.
Ano nga ba yung just compensation? Paano kadalasan? Kasi nagiging lugi yung may-ari ng lupa.
Just
Pero anong
just
gagawa nga ba natin?
compensation prior to the tunneling, and even just compensation as regards damages brought about by the tunneling, vibrations, etc., etc. Looking forward.
Mr. Chair, in case of expropriation, may I defer to the OSG, Mr. Chair? This is within the sphere of their knowledge and expertise. Thank you.
Ano ba yung Article 437 ng Civil Code? Ito yung tumatalakay sa karapatan ng may-ari na gumawa ng kahit anong konstruksyon sa ibabaw o sa ilalim ng kanyang pag-aari o property nang hindi na kailangan ng resolusyon o batas. The owner of a parcel of land is the owner of its surface and of everything under
the
it, and he can
implications
construct
of
thereon any works or
Article
make any plantations
437
and excavations
of the Civil
which
Code
he
of the
may deem proper
Philippines.
without detriment to servitude
The owner
and
of the
subject
surface
special laws and
is
ordinances.
the owner of the subsurface, and he can do anything, any construction beneath the surface.
O ha, di ba? Naunahan ko si Senator Francis Tolentino.
Yes, Mr. Chair, we in fact rendered a legal opinion to the DOTR regarding the provisional deposit on subterranean acquisition, Your Honor. And in that, Your Honor, we cited several cases. One of each is the National Power Corporation versus Ibrahim, where the Supreme Court, the High Court, applied Article 437 and awarded just compensation to the private property owner for the tunnels built by the NAPOCOR, Your Honor. We also cited the Department of Justice Opinion number 043, series of 2014, which says that any impairment to the enjoyment of the property, whether surface or subsurface, shall cause the property owner have rights to just compensation to the actual value of the property subject to rules and regulation and as determined by the competent court. However, we concluded in that legal opinion that for purposes of provisional deposit, the jurisprudence as well as the Right to Pay Act and IRR of Right to Pay Act is actually silent. So we suggested.
Interrupt you.
Yes.
With the permission of the chairman, isang tanong na lang po. So halimbawa po ito yung surface. Nag-tunnel dito. That's your Supreme Court decision. Article 437 states that the owner of this surface is the owner of the subsurface. Nag-tunnel dito sa ilalim, just compensation. Can the owner now dig beneath the subsurface below the tunnel? He's still the owner of that. Yung ban just compensation, hanggang doon na yun sa ilalim. Dito lang yun, dinaanan ng subway, halimbawa. Yung ilalim.
Mr. Senator, to be candid, the jurisprudence does not touch upon that subject, and I think it's a quite a complicated legal issue that needs to be studied deeper, Mr. Chair, because for the first time we're having subway projects in the Philippines, and that matter has not been discussed or even brought to court before, aside from this very first case of NAPOCOR versus Ibrahim, Your Honor.
It as well include that in your proposed IRR. Nothing can prevent the owner of the surface from touching the subsurface, even though a right of way was given beneath the surface. Very, very technical indeed. Pinalis ko lang yung antok nyo. Thank you.
Thank you.
Salamat, sir.
Salamat. Legal luminary.
Thank you.
And I hope that we contemplate, because Senator Tolentino is our resident legal luminary in the Senate. So, like I said, it goes back to what I said earlier, that this is, like you said, this is the first time that we'll be building using subterranean in an extensive manner. It's important that we tackle all these scenarios, like what Senator Tolentino said. Halimbawa, okay nga, paano yung ilalim? Under 10752, 50 meters. But there are other provisions in the law, in the Constitution, that give rights to the landowner. So how do we reconcile that? That's an interesting legal issue. Hindi naman ako lawyer, so DOJ, OSG, kayo ng mga legal sa gobyerno, dapat kasama yan sa pag-uusapan sa technical working group. And moving forward, I'd like to, I remember when I was, nung ako po yung secretary ng DPWH, isa sa mga naging problema namin was the I think one appraisal. One constraint was the speed of the appraisal process, because obviously limited din yung capability ng land bank, limited yung capability ng GFIs. So minsan sa dami ng mga cases, sa dami ng mga appraisals, doon hindi na, parang nade-delay yung project dahil hindi makuha kagad yung mga appraisal. So paano ba to ina-address ng right of way law? Does anyone, attorney, can anyone answer? Yes. Whoever can answer, please. Attorney Lapus. Sorry, Undersecretary Lapus.
Yes, Mr. Chair, under the proposed amendments, there are several schemes proposed to, one is the RP Vara. The proposal to include the schedule of market values to be considered as the purchase price for the lands to be acquired for right of way would be helpful, because that will eliminate the requirement for the procurement of independent property appraisers and the engagement of GFI. So if we have one value that will be followed by all, that will be the basis of the offer. Mr.
So
Chair.
there will no longer be an appraisal. So the only value you're proposing under the law, that the only value that will be used is the one that is established by the RP Vara. Kasi right now, when we expropriate, we deposit the zonal value to the courts, correct? And then once we deposit the zonal value to the courts, while they're determining the appraisal, the value of the property, they'll give us the writ of possession. So how would this change the dynamic? What is your proposed? Do you have something? Okay, please, Yusek Uy.
Thank you, Mr. Chair. Actually, so we understand that it's very important that we integrate our PIBARA already in the way that we value the property. But we're not just talking about land. We're also talking about improvements, as well as the replacement cost of structures and improvements, even market value of crops and trees, and other appropriate compensation. So So we still foresee the need to include independent property appraisers, but it's just a matter of, I guess the current law is very limiting in the way that it only accredits certain institutions to do the accreditation. So we can have more flexibility with respect to that. With respect also, I would just like to flag also for the other appropriate compensation, there are several versions that includes many different categories for these types of additional compensation. So like, for example, disturbance cost or income loss or even transportation costs, if I remember correctly, I think in the House version. So that's something that we can discuss in the TWG. What would be a reasonable inclusion of the category of the appropriate compensation?
Yes, and perhaps even and I don't know, this is something you consider, that also this is related to the presence of informal settlers in the properties, which of course under the law, technically they're not entitled to any, they're not, obviously they don't have ownership, but nevertheless, perhaps for humanitarian reasons, we can see how we can implement some sort of, I guess, I'm not sure, we have to look into this, and this is what we can discuss in the technical working group, but taking that into account for humanitarian reasons, what sort of compensation that could be given to those informal settlers for humanitarian reasons. I mean, when you talk about flexibility, perhaps that can be included in the flexibility that's given to the implementing agency. I think, Yusek, if you have any comments.
Yes, Mr. Chair. In relation to the values under the RP-VARA mentioned earlier as to the replacement cost, actually, we welcome the development that it is proposed that under the RP-VARA, the replacement cost shall be based on depreciated value, which is in line with our proposal to make it a little bit cheaper for right-of-way acquisition. Because as the law stands right now, replacement cost is based on the value that is required for the owners to be able to replace the value in present day values. So if we are going to follow the proposition under RP-VARA, depreciated cost, so its right-of-way acquisition will be cheaper. Another point, Mr. Chair, is in relation to, sorry, I forget my point already, but maybe later I'll remember. Yes, Mr. Chair. Foreign funded projects, sorry. For foreign funded projects, we've observed a discrepancy between our local laws and our loan agreements in foreign funded projects. There's a list of entitlements under foreign funded projects which is not supported by our local laws, which is the Right of Way Act. So we are at a quandary as to whether we will disburse these entitlements in foreign funded projects because it has been a source of COA observations, Mr. Chair. So we propose to standardize the entitlements, and we support if we are going to expand the entitlements under the amendments, Mr. Chair.